Old man, you know? Okay. We have Ms. Johnson.
Judge, Ms. Johnson is here, present at Maine, and she is approaching. And she declined to serve as a public defender.
Ma'am, you're charged with domestic battery. Court finds probable cause. Bond is set at an amount of $500. No contact with the alleged victim. Just keep all the no contact orders. I'll sign them at the end. Okay. All right. Tanata Flowers.
Ms. Flowers is here, present, Judge at Maine. She is approaching. Come on up, Ms. Flowers.
Ms. Flowers, you're charged with burglary with assault and battery burglary, occupied dwelling unarmed, domestic battery and criminal mischief. Court finds probable cause.
Your Honor, on the burglary with assault or battery, the punishable by life offense, the state would be seeking a finding of proof evident or presumption great, and a no bond hold for first appearance purposes only under Isaza v. State. Relying upon the probable cause affidavit, Your Honor.
And we would object to the court making a finding of proof evident presumption great at this point of the proceedings. The state's called no witnesses. They've introduced no evidence. They're relying solely on a probable cause affidavit written by an officer who did not witness the events. Therefore, proof evident presumption great, being the highest burden of proof that we have in the criminal justice system, has not been met, and we would ask the court not to make such a finding. If over our objection the court does make a finding of proof evident presumption great, we would encourage the court to exercise its discretion and set a bond for Ms. Flowers.
The court has reviewed the affidavit of the police officer. The court's understanding is the court must, if the state requests, the court must make a determination on that. What is before the court, on what is before the court is a probable cause affidavit. The probable cause affidavit is insufficient to find the proof evident presumption great. The court sets bond in count one, $2,500, count two, $1,000, count three, $500, no contact, no return to the property, and thank you very much.
Judge, two requests. One, would the court sign a photo order so we can photograph Ms. Flowers' injuries? And two, would you sign a property order so she can go back one time with law enforcement to retrieve her belongings? And, and I have a third request, Judge.
We didn't ask for the third. Now you're asking for the third.
Now I'm asking for the third. I apologize. But her, the alleged victim, have children in common. I would ask for purposes of arranging child contact, because they go through a third person, so she could have visitation with the children.
Okay. I do not know what Family Services or any of the other agencies have done, if anything. But it is my understanding that she can have no contact, and my order is she can have no contact with the alleged victim and the people who reside at that residence. But if the children reside with her and she is the natural mother, then she's the natural custodian.
Judge, the reason why I'm asking for this special exception, she's the mother. There's no court order or anything like that basically terminating her right. She takes care of the kids, but when she was arrested, the kids were left there. So now
I understand that. She has a right to go there with the proper
but
police
if your order
authorities
even
and
tries
pick
to
up
go
her
there,
kids.
It's going to be a violation.
No, not if she takes the police with her.
Okay, thank you, Judge.
Thank you. Have a good day.
Judge, the jail called and there was a case they wanted you to take out of order, if you're so inclined.
Okay, which one is that?
It's Mr. Snodgrass on page 11.
He's here, President Judge, and I've had an opportunity to speak to him. Come on up, sir.
Okay, thank you. Mr. Snodgrass, you're charged with dating violence. Court finds probable cause. Bond is set in the amount of $500. No contact with the alleged victim.
Judge, the only thing, would you sign an order so he can go back, one time with law enforcement, retrieve his property, and a property order so
You're
he
asking,
can have access to his
counsel,
wallet to
counsel,
self-bond?
counsel, if you're just asking to be able to access his property from bond, just ask for that. Just ask,
Yeah, access
can I have an
property.
order to access property? Fine. Can I?
Thank you.
Thank you.
Thank you.
Okay. Val Court.
North Broward, Your Honor, that's going to be a medical reset.
Thank you very much. And we have Chantel Georges.
North Broward.
Stand in front of Judge.
North Broward?
Yes, Your Honor.
Okay.
She doesn't want to walk up here, Your Honor, but she hears you. Gorgeous.
I don't know either, but we'll, you know.
She's refusing.
Ask her if she'd like to get out of jail.
No, I don't want to talk. Thank you.
Did you tell the judge she refused that?
Put her on recall.
Your Honor, I can advise you,
She's refusing,
she has a
Your Honor.
pending case before Judge Leonard Wren in mental health court.
It's not surprising.
So I just would ask that this case can
No, I'm
also.
putting her on recall. We can't even get her up.
No, yeah, if she's refusing though, I mean, you know.
Lenice Thomas.
North Broward,
North
Your Honor.
Broward.
How you doing?
Okay, you're charged with petty theft to the second degree. Court finds probable cause, and you're charged with assault. On the assault charge, the bond is the amount of $100. And on the petty theft charge, no bond is required. The bond is $100.
Judge, I was going to ask the court if you would consider pretrial release for Ms. Thomas.
Not at this time. Lori Kudlik.
He's approaching, Judge. You see her present? At Maine?
Okay, Lori Kudlik. You're charged with battery. The court finds probable cause. Bond is set in the amount of $1,000.
Judge, one request, Judge. In speaking to Ms. Kudlik, my understanding is that this incident occurred at her own property, where the person, the alleged victim, came onto her property. My understanding is, Judge, the touching was incidental. Having said that, I'm going to be requesting the court consider an ROR on her behalf.
Okay. Court sets bond the amount of $500, no contact with the alleged victim. She may return to her property.
Thank you.
Okay. Phoenicia Fisher.
North Broward, Your Honor. She's a medical reset.
Ashley Goodard.
She's approaching, Judge.
Judge, we have a corrected on Ashley Goodard.
At Maine, Judge.
Okay, we got Ashley Goodard. Okay. I've got 12 counts of an Audi County hold. The bonds are set, and she has one felony capias in Broward for $1,000. And then the bonds are respectively set in the amount of $10,000, $2,500, $2,500, $2,500. Wait a minute, is that 2,500 or is it?
Stuff up.
Yeah, 2,500, 2,500, 2,500, 2,500, 2,500, 2,500, and 2,500. Those are all Old County holds.
We have a corrected in reference to Ms. Goodard. The case number on count one We corrected, it was incorrect for the grand theft. And she has an additional, she has 13 counts for the ICS county. Clerk will make that correction for you. Just wanna
Okay,
let you know.
what's the correction on one?
One, it should be 19003350 CF 10A.
Was there?
And then she had another count of,
There's a space
unlawful
between the C and the
possession
F.
ID for another $2,500.
All right, so she has an
She had
additional,
13 counts
she has 13 counts,
instead of 12.
okay, which are out of county hold,
Yes,
and that's for 2,500.
another 25.
But was the count one, 1,000, is that correct?
Yes, the amount is correct.
Okay, thank you.
Judge, what was the 13th count, because we didn't hear?
All out of county holds,
Right.
okay.
And all for the same thing and a $2,500 bond.
each, 12 counts. Okay, Michelle Gallerano,
Ms. Gallarino is approaching, Judge. She declined to serve as a public defender.
I have private
okay, Ms. Gallerano, you've got felony capiases, no bond hold. You'll be detained going before the judge on the 17th. That's Judge Tobin Singer, and you have a
That's the
grand
earliest I
theft
can see her.
$1,000 bond. Have a good day, ma'am. Find probable cause.
Our Spanish interpreter is here.
Sabrina Woodrick.
North Broward, Judge. Sabrina Woodrick.
Do we have Miss Woodrick, or do we need to put it on route?
Yes.
Put it on recall. Jennifer Lake.
Jennifer Lakes, North Broward, Your Honor, that's a medical reset.
Thank you. Chardonna Coleman.
Bond posted,
North Broward, Your Honor.
bond posted,
Bond the Chardonna bond has been posted for you.
probable cause is,
Oh, thank you.
Thank you, ma'am. Find probable cause on her. Sarah Eat.
She's here present at Maine.
Marizolu Joseph.
She's here at Maine.
Okay. You're charged with burglary of an unoccupied conveyance and petty theft. Court finds probable cause. Bond is set in the amount of $1,000 on count one. No bond required on count two. Can you make the $1,000 bond, ma'am?
She
Ma'am,
cannot,
sir,
Judge.
just a second. Can you make the $1,000 bond, ma'am?
No, sir.
Okay, state.
Your Honors, Ms. Mary Yosef currently has a warrant out of the state of Georgia from 2014 for a violation of probation for possession of heroin. I'm getting hits out of, there's multiple priors out of the state of Georgia, Your Honor.
You know if the warrants are any good?
They're not extraditable. The point I'm making, I'm just bringing to the court's attention that she is wanted out of Georgia for a violation of probation.
And my understanding is about 5 years old, Judge. She's a stay-at-home mom taking care of an 8-month-old child. Her boyfriend's the only one supporting the whole family. He can't afford it. We're asking for a pretrial release for her to be released under supervision.
Well, okay. Ma'am, if these charges from Georgia are valid, even though I may place you on pretrial release, you will not be released today.
It's in-state pickup only. It's not extraditable, Your Honor.
Excuse me?
The warrant is not extraditable. It has to be in-state pickup only.
Oh, okay, well then, fine. Ma'am, pretrial release. Have a good day. Shazikia Thomas?
North Broward.
North Broward, Your Honor.
Ma'am, you're charged with battery on a law enforcement officer, $1,000, resisting without violence, $500, no contact, no return. Court finds probable cause. Have a good day. Davian Reyes.
Mr. Reyes.
1,500.
He's here present, Judge. He's going to require a Spanish interpreter.
Spanish interpreter, please.
She's here.
Thank you. Good morning, young lady. Raise your right hand. Swear to tell the truth, whole truth, nothing but the truth, so help you God?
I do.
And would you state your name?
Maria Salazar.
And you swear to interpret from English to Spanish and Spanish to English as accurately as possible?
I do.
Thank you.
You're welcome.
Now, Mr. Reyes,
Señor Reyes,
you've got an out-of-county hold.
tiene una
It's actually, it's the state of
condado
Virginia.
del estado de Virginia.
There is a no bond. You'll be detained going before the extradition court, and that will be explained to you. If you waive extradition, you will be processed for Virginia to come and pick you up. If you do not waive extradition, you will have to go through the extradition proceeding. But they will be explained further to you later this week in extradition court. Court finds probable cause. Okay. And he's got 2 cases. Then we have Juan Murray.
Judge, I believe we just skipped Mr. Armando Reyes.
Hang on. Oh, I'm sorry, we did. Armando Reyes.
Armando Reyes.
Judge, we have a correction on Mr.
Ellos son hermanos. Oh, okay. They're brothers, Judge.
Yes. Partners. Sir, you have an out-of-state hold from the state of Virginia. It's a no-bond hold. You'll be detained going before the extradition court.
Fianza y va a ir a la corte de extradición esta semana.
Okay, Juan Carlos Murray.
Mr. Murray is approaching, Judge, and he declined to serve as a public defender.
Mr. Murray, you're charged with domestic battery, bond is set in the amount of $500, no contact with the alleged victim. James Haddix.
Mr. Haddix is approaching, Judge, and he declined to serve as a public defender.
Mr. Haddix, you're charged with battery, domestic, court finds probable cause, bond is set in the amount of $500. You've got an out-of-county hold in the amount of $15,002 in Nassau County. If you post bond here, you can post bond for Nassau County, but if you don't post, you'll be detained going to Nassau County. Have a good day. Osby Miller.
Mr. Miller, come on up, please. He's approaching, Judge.
Mr. Miller, you're charged with battery. Court finds probable cause, $1,000 bond. You have a violation of a domestic violence restraining order, $2,500 bond. Court finds probable cause.
Your Honor, he's also on pretrial for a battery in case number 19493MM10A, and pretrial is requesting that you revoke.
And you also have a battery charge, again, the court, which you were on pretrial for. Court sets bond the amount of $1,000. And sir, I'm going to reiterate, what do you want?
No, it's not with you, Judge. I just want to talk to pre-trial when we're done.
I was going to reiterate, you have no contact with the individual. And so if you have any further contact, you're probably on a no bond hold by next time you go around. Okay.
Judge, we have one more person who speaks Spanish.
You have one more what?
One more Spanish speaker
Okay,
before we can let the interpreter go,
all right.
because we might have trouble getting
You know
her back
which
later.
one-
Page 29.
All right. What's the person's name?
That's what I'm waiting for.
William Bell on page 29.
That would have been my last choice of the names on page 29.
He's here, and he declined to serve as a public defender, Judge.
What's his name? Bell?
William Bell. Español. Sí, en español. Ahí hay el intérprete.
Okay, I got him. William Bell, you're charged, sir, with trafficking cocaine, bond is set in the amount of $15,000, possession with intent, $2,500 bond, and driving while license suspended, $100 bond, court fines, probable cause, all counts. Have a good day, sir. Thank you. Thank you very much. Then we have Arcadio Torres.
He's here present, Judge, and he requires a Spanish interpreter.
Okay.
What page, I'm sorry?
Mr. Counsel?
I'll wait till you're, if I can just be heard after, once the court makes a probable cause determination.
Okay. On Mr. Arcadio Torres, there are two
Torres.
capiases. Bonds are set in the amount of $1,000
Están
each.
dando
Court fines
$1,000
probable
cada
cause.
cargo de los cargos y la corte encuentra causa probable. Señor Arcadio Torres.
State would request a no victim contact order on each case.
Absolutely.
La fiscalía está pidiendo de que no tenga usted contacto con la víctima.
Sir, you're to have no contact
No puede
with
tener
the
contacto
alleged victim.
con la supuesta
That
víctima.
means you're not to
Eso
come
quiere
within
decir
500
que
feet
usted no se puede
of
acercar a
that
más de
person, not go to
500
that
pies,
person's residence,
de
not
esa
come
persona,
in, contact
no
them
ir a la
directly, indirectly,
residencia de esa
even through
persona,
anybody else.
no la
You
puede
understand that?
contactar ni directo ni
Thank you.
indirectamente o a través de terceros.
Have a good
Gracias.
day. Craig Williams.
Mr. Williams is here present, Judge, in Maine, and he's declined the service of public defender. Come on up.
Mr. Williams, you're charged with battery, court finds probable cause. Bond is $1,000, no contact with the alleged victim.
Hey, Your Honor, the situation.
I don't,
happened on
hey,
my
you,
property-
I don't know what that is. Now, you want to say something, sir?
Yeah, the situation that happened on my property, Your Honor.
Sir, a bond is set in the amount of $1,000. You have no contact with the victim. You can return to your property, but you can't have any contact with the victim. Have a good day, sir. Melvin Cross.
Mr. Cross is approaching, Judge.
Mr. Cross, you've got a capias for a battery $1,000 bond. Court finds probable cause.
Again, we just request a no contact order, Your Honor.
Yes, well, no contact. I do on every battery.
Yeah, I just want to make sure because it was on a capias.
Okay. You understand? No contact with the victim. Have a good day.
Judge, Mr. Cross is requesting if you would consider releasing him on pretrial release.
No,
So I,
not at this time. Audie Jones.
Mr. Jones, come on.
Mr. Jones, you're charged with domestic battery. The court finds probable cause. Child neglect, count 2. Court finds probable cause. Child neglect, count 3. Court finds probable cause. Bond is set in the amount of $1,000 each count. No contact with the victim of the battery. No contact with the minor children. Guardian ad litem is appointed to represent the interest of the minor children.
Judge, we're going to be asking if the court would consider releasing him on pretrial release. I understand this.
No,
person
not at this
ever in
time.
life.
Not at this time, counsel. Snyder Victor Hilton.
Mr. Hilton is approaching, Judge. He's approaching.
Mr. Hilton, you're charged with domestic battery. The court finds probable cause, or this is dating violence. Bond is set in the amount of $500 on count 1, count 2, criminal mischief, $500, no contact with the alleged victim. Okay, we have Javier Sotolongo.
He's approaching, Judge, and he's going to require a Spanish interpreter.
Okay, do we have the Spanish interpreter?
She just left.
All right, put him on recall. How does that work? We get the interpreter back later on? Yeah, okay. Maybe want to wait till we get towards the end of the docket in case we have more? Okay. Edward Kelly.
Is
Judge,
that,
I think I've been advised medical loan.
He's medical?
yes, yes, sir.
Thank you very much. Now we have Adonis Anderson.
All right, Your Honor.
Adonis Anderson, you've got a battery charge. It's been, this is an ad charge.
It's-
How did I get ad charged?
Joe,
What?
did they take care of this? Because it's supposed to
It's,
be.
oh, this is a violation of, this is a violation of pretrial release?
Your Honor, it should be two
I don't
charges.
understand.
There's a change of charge and an add charge, Your Honor. The felony battery was an upfile from misdemeanor battery, and the violation of pretrial release conditions was an add charge. I can advise the court, and I provided the court with a
She
copy of
came
the
to
piece.
my house. She keeps coming to my house harassing
Sir?
me.
Your Honor, I provided the court with a copy of the information and probable cause affidavit. I can advise you on the battery, when he first had his first appearance, I'm showing the bond was set at $2,000. I imagine the court was aware of his criminal history when that bond was set. So I'd ask that, even though it's been upfiled, I have no objection to the same bond being kept in place, 2,000. And he does have the new charge, the violation of pretrial. That's from a violation of a no contact order from a battery that's still pending against the same victim.
Do we have the, I don't,
It's not a violation of pretrial release supervision, it's pretrial release conditions, that being the no contact order from the court.
but I don't set bond on that one, do I?
Yeah,
Okay.
it's a charge, yeah.
Court finds probable cause on the refiled battery, $2,000 bond. On the violation of restraining order, $2,000 bond. Have a good day.
Your Honor,
No
there's-
contact with
Thank
the
you.
alleged victim. Carl Peter Bergman.
All right again, Your Honor.
Mr. Bergman. This is an ad charge of battery, domestic violence to an ag assault. The court finds probable cause. State, did you have anything?
Your Honor, bond on the ag assault was set at 15,000 with a GPS monitor, whatever the court deems appropriate, I'm fine
Okay.
with.
Court's a $1,000 bond. Have a good day. No contact.
Yeah, I know that.
All right, now. Harmon Hunter.
He's approaching, Judge.
Mr. Hunter, you have a battery on a pregnant woman. Court finds probable cause, bond set in the amount of $500, but you've got two violations of probation, no bond hold. You'll be detained going before Judge McCarthy on the 17th. No contact with the alleged victim. Have a good day, sir. Donavita Cummings.
Approaching, Judge.
You're charged, sir, with aggravated assault with a deadly weapon, domestic violence. Court sets bond the amount of $2,500, throwing a pistol into a building, $2,500 bond, and you've got a violation of probation, no bond hold. You'll be detained going before Judge McCarthy on the 17th. No contact, no return to the property. Have a good day. Joshua Ross.
Conti, Your Honor.
Judge, Mr. Cummings, would you sign a medical screening order?
Granted. Okay, Mr. Ross, we've got a capias for $1,500 on a petty theft. And because you're in jail and it's an ad charge, I can't offer you a plea on it at this time.
And he's got a no bond hold on count one
Right.
either way, Your Honor.
Okay. Have a good day. Wayne Goldman.
Yes, Maine, Judge? Maine?
Got it.
It's a city violation if he wants to would like to resolve his case today.
He's just
Okay, counsel,
Just here in state charge.
you're representing Mr. Golden?
That's all I have.
Yes, I'll speak tonight for him, Your Honor, on the city cases.
Okay,
Yeah, Your Honor, and I don't, see, I only had the paperwork for the state charge, but I guess they put all the charges on the docket, so I don't know what's.
well, the other charge is municipal ordinance,
Yes,
okay? And, counsel, what do you want to do?
Judge, you want to resolve our 3 municipal ordinance cases?
Want to resolve them all?
Yes, Your Honor.
Okay, count 1, count 2, count 3 is, time served, count 4 is withhold. Have a good day. Then we have Tyler Allen.
Tyler Allen, come on up.
Mr. Allen, you've got 3 capuses. Count the 1 and 2 are $500, then count 3 is $2,000. Do you want to plea out counts 1 and 2?
Yes, sir.
Okay, time served. On count 3, ROR. Sir? Mr. Allen?
Oh, Mr. Allen, come on back, sir. He's approaching.
Make sure you show up in court on this one, because the next time you won't get out.
Yes, sir.
If you don't, have a good day. Nary Seller.
He's approaching, Judge.
Mr. Seller, you have a possession of cannabis, $500 bond, court finds probable cause, but you have an out-of-county hold for $10,000. That's out of Monroe County. Counsel, you representing him on the count 1?
Yes, Judge. My understanding is, Mr. Quire, I believe he wishes to resolve the matter.
And do you want to plead out count 1?
He does.
Okay, withhold, and then you've got to postpone or resolve the thing down in Monroe County. Have a good day, sir. But if you can't postpone, they'll take you to Monroe. Felipe Canal. You can take my.
He's approaching, Judge.
Mr. Cannell, you're charged, you got 2 capuses, $500 each. They're both for driving, one's for driving with a suspended driver's license, the other one's for expired DL. The court will RR them on count 1 and count 2. And, sir, you need to show up in court. You understand?
All right.
Do you understand?
Yes.
Okay. You're out of there. Matthew Inverzo.
No prayer, Your Honor.
It's a city violation, Your Honor. We'd like to resolve his case.
Okay. See North Broward?
Yes,
Ah,
Your Honor.
Mr. Inverzo, you got an open container violation. You want to plead no contest?
No contest, please.
Time served.
Thank you, sir.
Have a good day. George Staples.
North Broward, Your Honor, that's going to be a medical reset.
Thank you. Lorenzo Delgado. Anybody have Lorenzo Delgado? Does he need an interpreter?
There's no problem.
You have a municipal ordinance violation.
Tiene una
You
violación
want to
de
plead no contest, it's an
ley
open container.
municipal. ¿Quiere declararse que no disputa a la bebida alcohólica abierta? No contest.
Time served. Have a
Tiempo
good day.
cumplido. Tenga buen día.
Let's make a recall, Madam Interpreter, let's make a recall of Javier Soto Longo.
Oh, he's approaching.
Okay. Mr. Soto Longo,
Señor Sotolongo,
you're charged with aggravated assault
se
with
le
a deadly
acusa
weapon.
de agresión con agravantes con arma mortífera.
Bond is set in the amount of
Es
$3,000.
$3,000 la fianza.
Aggravated battery
Agresión agravada,
causing physical harm.
causando daños corporales.
Court finds probable
El
cause.
juez haya motivo justificado.
Bond is set in the amount of
Son
$2,500.
$2,500.
Domestic
La fianza.
battery by strangulation.
Agresión con doméstica por estrangulación.
Court finds probable cause.
El juez haya motivo justificado.
$1,000 bond.
$1,000 de fianza.
Tampering with evidence.
Manosear la prueba.
Court finds probable
El
cause.
juez haya motivo justificado.
Bond is set in the amount of $1,000.
$1,000 la fianza.
There'll be no contact
No
with
va a
the
haber
alleged
contacto
victim.
con la alegada víctima.
Have a good day.
Tenga buen día.
West.
North Broward, Your Honor.
Mr. West, you got some municipal ordinance violations, 3 of them. You want to plead no contest to them, open container?
Yes.
Time served.
Thank you, sir. Thank you, Judge.
Charles Sinclair.
He's here.
Water violations, municipal violations.
There we go. Charles Sinclair, got a municipal ordinance violation. You want to plead no contest?
Yes, sir.
Time served.
Thank you, sir.
Todd Karwuski.
He's approaching, Judge. It's your main.
You're charged with disorderly intoxication, $25 bond, court finds probable cause. You want to plead no contest?
Do you want to plead no contest?
You can resolve that.
Time served. John Grady.
Grady, come on up, please. He's here.
John Grady, you got a trespassing charge, $50 bond, court finds probable cause. You want to plead no contest?
Yes, sir.
Time served. Michael Cunningham.
He's approaching, Judge, your main.
Possession of paraphernalia, $100 bond. You want to plead no contest?
Yeah.
Time served. Stevie Billy.
North Broward, Your Honor.
Bond it, thank you. Jacqueline Leon, Nunez Leon.
Mr. Nunez is here present, Judge of Maine.
Mr. Nunez, you've got a DUI, $500 bond. DUI property damage, $1,000 bond. DUI property damage, $1,000 bond. Total bond, $2,500. Can you make the bond?
No, Your Honor, I'm a disability.
Court at this time places him on pretrial release, special condition of pretrial release, no alcohol or intoxicants, pending trial. Have a good day, sir. Alfredo Bax.
He's behind the judge.
Thank you. Glenn Blakely.
He's here present, Judge of Maine.
Okay.
Oh, he declined, Judge.
All right. Mr. Blakely, you've got a capias, $500, court finds probable cause, petty theft. You want to plead no contest?
Yes, sir.
Time served. Okay. Heaven Henry.
No prayer, Your Honor.
Mr. Henry, you're charged with trespassing, find probable cause, bond set in the amount of $100. Counsel,
I'd like to resolve this case, Your Honor.
you want to plead no contest?
This is the state.
Time served.
Oh, he's not. He's a friend.
Brian Bernadelli.
Pro bono.
He's approaching judge here at Maine. Judge, he declines to serve as public defender.
Your Honor.
Okay, you got a possession of someone else's ID illegally, $1,000 bond, court finds probable cause. Can you make the $1,000 bond?
No.
Okay, pre-trial release.
Your Honor,
What? Hold on.
he's got no bond holds on court order, no bond holds. He's not getting out of custody regardless.
You have a no bond hold on a separate case? All right, I'm gonna leave the $1,000 bond on this one. Have a good day. Javier Barola.
No prayer, Your Honor.
Mr. Brewer, you're charged with the ad charges, counts 3 and 4, of burglary on occupied dwelling, bond set amount of $2,500, grand theft, $1,000 bond, find probable cause. On these two charges, total of $3,500 bond. Matthew Comstock,
Conti, Your Honor. Conti.
Mr. Comstock, you've got two ad charges. Burglary on occupied, $2,500 bond. Grand theft, $1,000 bond. Total, $3,500 bond. Find probable cause. Have a good day.
Your Honor.
David Coffell.
Judge Bernard Sewell, my understanding according to the document was removed, no paperwork.
Fell?
Oh, no, I'm sorry. I don't wrong.
Coffell, that's okay.
He's not for.
Mr. Coffell is not for magistrates? Delete it, thank you. Louis Apuzzo.
He's approaching judge here at Maine. Come on up, sir.
I'm just saying this.
That's okay, that's all right, that's all right. Mr. Apuzzo, you're charged with trafficking cocaine, $25,000 bond, possession of Xanax, $25,000 bond, possession of heroin, $25,000 bond, keeping a public nuisance, $1,000 bond, drug paraphernalia, $1,000 bond, court finds probable cause, all counts.
Your Honor, the only other request I'm going to make on the record, if the court would impose the special bond release conditions that Judge Williams also set on the warrant. I'm referring to.
What special conditions are those?
Your Honor, it would be, and I'm referring to, if you look at the end of the warrant, it's,
I don't have that, I don't think, let me just.
I think you should, yeah, I believe you do have it, Your Honor. Right, it's right after where he sets the bond amounts.
All right, what is it, I'm not,
Number one would be, that the defendant shall secure his release pursuant to a surety bond that is fully collateralized. The net asset value of the collateral must be in an amount equal to or greater than the bond amount. Condition 2 sets a nebia requirement. 3, just that he's only eligible for release after the court has had an opportunity to review the nebia and collateral paperwork. 4, that any property used to collateralize the bond should not be further encumbered or liquidated during pendency of the bond.
Okay.
That the surety shall provide to the state a title search within 10 days of the defendant's release. That the defendant be monitored by pretrial release services. And that the defendant will not possess any firearms. And that prior to his release, he will surrender his passport and that to the Broward County Clerk of Courts. And shall not reapply. Thank you.
Judge, I'm going to be asking you not to impose those special conditions. My understanding, this is the first time he's been arrested on a trafficking offense. He works as a handyman construction, so the $75,000, which is currently set, is something he can't afford. And $50,000 is set alone on counts 2 and 3, which are third-degree felonies. He's been here his whole life. He lives with his father. His father is retired. They're not going to be able to come up with that. Judge, I'm asking you to, at this time, not impose the special conditions and to lower the bond from $75,000 to $7,000 on his behalf.
Court at this time denies your motion to reduce bond. The court is going to maintain the bonds and the conditions as set by the judge who signed the warrant, and the court is not making any changes whatsoever. Okay. Seymour, Taurus Seymour,
North Broward.
Medical reset, Your Honor.
medical, thank you. Arnano for single? For single?
Yes.
No time, Your Honor.
sir.
Okay. You've got a capias for $500 on a resisting, and you have a capias on a $500 capias for trespassing, and then you have warrants for violation of, is this pretrial release? No bond, no bond, no bond. Court finds probable cause, you'll be detained going before the judge on the no bond hold, Judge McCarthy, on the 18th. Have a good day, sir. James Black.
He's here present at main, Judge.
Mr. Black, you got possession of cocaine and possession of ecstasy. Bonds are $1,000 each, total $2,000 bond. Can you make the $2,000 bond? No?
Your Honor?
Yes or no?
Hector, the judge didn't hear his answer.
Is that yes or no? Can he?
No.
He cannot. Fine. State?
Your Honor, Mr. Black was arrested May 30th for possession of cocaine, is out on a $1,000 bond on that current pending charge. As you can see, it should be attached to your report. He is also a qualified designated career offender in the state of Florida.
All right, I'll leave the bonds as is. Have a good day. Austin Pericles?
He's approaching, Judge.
You're charged with petty theft, $25 bond, battery on a law enforcement officer, $1,000 bond, resisting an officer without violence, $500 bond, and the trespassing, $100 bond. Court finds probable cause. Can you make the bonds?
No.
Pre-trial release. Keith Johnson.
He's approaching, Judge.
You're charged with robbery without a firearm or weapon and criminal mischief. Court finds probable cause. Court sets bond on count one, the amount of $5,000. Court sets bond at on the criminal mischief charge, there's a $25 bond. And you will have no contact with the alleged victim and no return to the property. Joseph Lacayo.
He's approaching, Judge, here at Maine.
No, I'm telling you, we don't.
Mr. Lacayo, you're charged with burglary unoccupied, $1,000 bond, petty theft of third degree, $1,000 bond. You got a violation of probation, no bond hold. You have a burglary unoccupied conveyance, $1,000 bond, petty theft of the first degree, $750 bond. Then you've got a violation of community control no bond, and illegal use of a credit card, $1,000 bond, and burglary, $1,000 bond. Then we have that's counts 1 through 8. Then we have counts 9, petty theft, $25 bond, illegal use of a credit card, which are counts 10, 11, 12, 13, 14, 15, is $1,000 bond each. And then you have a violation of probation, no bond hold. You'll be taken before the judge who issued the no bond hold. Thank you.
Judge Murphy. On
Yes.
count 2, that is the misdemeanor petty theft, you said 1,000?
I'm sorry, count 2, I should have been 100. Then we have Jorge Cruz. Mr. Cruz,
Bonded, Judge?
bonded, thank you.
Judge, find probable cause, please, I still have this.
I found probable cause, all counts, sorry. Ian Robert Gay.
He's approaching, Judge, you remain.
You're charged with trafficking in amphetamines, $50,000 bond, drug paraphernalia, no bond required. Court finds probable cause.
Your Honor, he's also on pretrial for carrying a concealed firearm, possession with intent to sell, manufacture, or deliver MDMA, and drug paraphernalia. We're asking that you revoke his pretrial, please.
Pre-trial, you've got a violation of pre-trial, carry concealed firearm, bond is set in the amount of $2,500, possession of MDMA, ecstasy with intent to deliver, $2,500 bond, and possession of drug paraphernalia, $100 bond. That's on the other charges. Have a good day, sir. Lionel Beaumont, or Beaumont.
He's approaching, Judge.
Mr. Beaumont, you got a possession of cocaine, $1,000 bond, and then you've got a traffic, capias, court will ROR you on the traffic capias, $1,000 bond on the possession of cocaine, court finds probable cause. Sir, can you make the $1,000 bond?
I ain't got her.
No, Judge, you can't.
Okay, pretrial release, special condition of pretrial release, that you have a drug evaluation and any follow-up treatment that is required. Devontae Suki?
On, sir. I go ahead. Don't.
He's approaching, Judge, you remain.
Mr. Stuckey, you're charged with burglary unoccupied of a dwelling, $3,000 bond, capias on the traffic, $25 bond. Court finds probable cause, all counts, no return to the property. Carlos Hernandez.
Mr. Hernandez?
Okay. You're charged with robbery by sudden snatching without a weapon. Court finds probable cause. You have a misdemeanor capias, $500 bond. Bond is set in the amount of $7,500 on the robbery charge. No contact with the alleged victim.
Degree felony, Mr. Hernandez advised me he can't afford that. Would the court consider releasing him on pretrial release?
No, sir. Eric Lopez.
He's approaching, Judge.
You're charged with possession of cocaine, possession of methamphetamine, and possession of paraphernalia. Bonds are set in the amount of $1,000, $1,000, and $100 respectively. Court finds probable cause. Can you make the $2,100 in bond?
No, I can't afford it.
No, he can't afford it.
Pretrial release. No, because special condition of pretrial release, you have drug screening and any treatment or counseling that's recommended. Robert Sissel.
Mr. Sissel, come on up. Mr. Sissel, he's approaching, Judge.
You're charged, sir, with possession of cocaine, $1,000 bond, possession of paraphernalia, and you've got traffic capuses, operating without a valid driver's license, possession of drug paraphernalia, and driving with a suspended driver's license. Bonds are set in the amount of $250 on each one. Sir, can you make the bond?
No,
Bond's
sir, no, no, no.
$1,750.
I just got back to work, Your Honor. I have a job with Bob.
I asked the question, sir, can you make the bond?
No, sir. Sorry.
Okay. The court will place him on pretrial release, special condition that he have a drug evaluation and treatment if warranted or indicated on counts 3, 4, and 5 ROR.
Judge, on counts 3, 4, and 5, the KP is for the operating and possession, driving license suspended. He wishes to resolve it. Would the court be inclined to resolving those matters?
But if he pleads out to the drive with a suspended driver's license, it could habitualize him.
Oh, yes, he can.
Yeah, right.
I have one class.
Okay, all right.
Okay. Daniel Rodriguez.
If I could make a bond request before the court sets a bond.
Judge, Mr. Rodriguez is approaching, and we're going to be waiving formal reading of the charge.
Okay, Mr. Rodriguez, you are charged with a felony, lewd act. You're also charged with possession with intent.
It's cocaine, not codeine.
Okay. With cocaine.
What?
Okay.
What a difference a few letters makes.
State, you wish to be heard?
Thank you, Your Honor. Just relying upon the probable cause affidavit that I know the court is familiar with, Your Honor, the state would be requesting a $50,000 bond on count 1, pretrial release with the GPS monitor level 2, no victim contact.
All right. The court at this time, defense, you wish to be heard? Mr. Reedy?
Nothing to add at this time, Judge.
Okay, court at this time, on count 1 sets bond the amount of $50,000. On count 2 is $2,500. No contact with the alleged victim. If he posts bond, he will be on pretrial release with GPS. And he will not return to that property. And the court appoints the guardian ad litem to represent the interest of the minor child.
Thank you, Judge.
Have a good day.
Yeah.
Omari Goings.
Mr. Goings, come on up.
Sheila, the bond wasn't posted? Bond wasn't.
Mr. Goings, you're charged with possession with intent to sell marijuana, $5,000 bond, possession with intent to sell cannabis, $5,000 bond, intent to sell cannabis, $5,000 bond, possession with intent to deliver oxycodone, $2,500 bond, possession with intent to sell or deliver oxycodone, $2,500 bond, and possession with intent to deliver cocaine, $2,500 bond. Court finds probable cause, all counts. Have a good day, sir.
Mr. Goings is not going to be able to afford a post bond. This is his first time being arrested in his life. He works for a moving company, Judge. Would Your Honor consider lowering the bond or releasing him on level 2 pretrial? Since this is
Not
his
at
first
this, not at this time.
And just to advise, if Your Honor's keeping the bonds in place, further.
DeAndre Reginald Gordon.
Bonded.
Bonded, thank you.
Not the first time. Exactly.
Michael Woods,
Medical
medical loan.
medical. James Lee Saunders,
He's approaching, Judge.
Mr. Saunders got petty theft, subsequent or third offense, bond $750. Use of a false ID, $1,000 bond. Then you have a violation of probation, no bond hold. You'll be detained going before the judge on the no bond hold on the 17th. That's Judge Sigel. Find probable cause, all counts. Edward Jenkins.
He bonded, Judge.
David Harrison.
Is he remain?
Mr. Harrison, you're charged with possession of amphetamines. You're charged with tampering with physical evidence and violation of probation. Bond are set as amount of $1,000 each. Counts 1 and 2. On the VOP, you got a no bond hold. You'll be going before Judge Bailey on the 17th. Court finds probable cause, all counts. Mark Rudnick, I'm sorry.
I guess that was a recess. That's what I was asking. That's what I was asking about yesterday.
You're charged, sir, with grand theft auto, $1,000 bond, possession of cocaine, $1,000 bond, possession of methamphetamine, $1,000 bond, possession of clonazepam, whatever, $1,000 bond, possession of cannabis, $100 bond, and grand theft auto, $1,000 bond. Court finds probable cause. Total bonds are $5,100. Sir, can you make the bond?
No, sir. No, sir.
Just want to advise the court of Mr. Rudnick's criminal history. 2016, passing counterfeit bills, criminal use of personal identification information, violated probation, sentenced to 2 years state prison. 2012, dealing in stolen property, 3 counts. 3 counts of false ownership info on a pawn
Okay.
item.
Counsel, I got you.
Okay.
Bond will remain as is. Okay. Erikel Watson.
Yes, how you
North
doing?
Broward, Your Honor.
How you doing?
Mr. Watson, you're charged with possession of Xanax, $1,000 bond. You got a violation of probation, no bond hold. And actually, you got 3 of those. And you'll be detained going before Judge McCarthy on the 14th.
Okay.
I believe that's today.
The 17th, Judge.
Have a good day, sir.
Things work out.
On the 14th today?
Yeah, you're
No,
gonna.
it's the
I don't know.
17th.
I don't know, sir. But
It's-
you'll be brought before Judge McCarthy next week, if not today. Okay, Willmouth Hughes.
Bonded.
Yes, sir.
Thank you. David Mills.
Oh, no, Mr. Hughes is here, Judge.
He posted bond, but since his arrest, he was on pretrial. His judge signed a violation of pretrial warrant. He's being held no bond on that.
Do we have Mr. Mills? Okay,
He's here.
Mr. Mills, you got in the third account
No,
3.
wait, Your Honor. Hector,
This Hughes.
I know he posted bond on this, but he's not out of custody because he's being held no bond for violating his pretrial on a separate case.
Let me explain it to him what
Okay,
happened.
this one's $3,500 bond.
Your Honor, that's not Mr. Mills. I
Right.
don't know where he is. Does anyone have Mr. Mills? Anyone?
Mr. Mills is here.
Okay.
Mr. Mills has got a hold on a pretrial release, and he has with $3,500 on the attempted. So while he's posted bond, he's being held on the no bond.
Your Honor, that was on the other gentleman.
Oh.
This is on the case where it's technically a change of charge, but Judge Powell found PC for attempted burglary and set the $3,500.
And the bond's $3,500. Sir, your bond's $3,500 on that count. And then we have Ainsworth McGregor.
He's approaching, Judge. Waiting for a reading of the charge.
Ainsworth McGregor, you're charged with armed kidnapping and attempted sexual battery. Court finds probable cause, all counts.
And Your Honor, this is a technical, on the kidnapping, it's a technical change of charge. On the second offense, it is a down file. I provided the court paperwork. As you can see, the court, at his first appearance, found proof evident of presumption great for kidnapping. For some reason, he was booked under one subsection of kidnapping. Your Honor, I'd ask the court to impose the original court's finding and no bond hold on that. And then if I could address the court as far as the bond on the second count, I provided the court with the original arrest warrant affidavit. Your Honor's familiar with the facts. I'd be, based on the allegations, and I want to also advise the court, he's also being held on a charge of attempted felony murder on this case. I'd be requesting a $150,000 bond, Your Honor.
But it's a no bond hold on count one, correct?
If you
what you're
keep the
asking.
original court's
Right.
ruling in place, yes.
Defense?
I know what he says. Not me.
All right.
I looked at it, that seems to be the case.
All right, at this point, count one is no bond hold, and count two is that an attempt?
It is, Your Honor, that's why he's bond eligible.
Okay, $50,000 bond. Court finds probable cause, all counts. Okay. Now we have Chantel Georges, who's on recall.
North Broward.
Do we have Chantel?
I think it might have been Miss Woodrick.
No, it's both.
No, we got, well, yeah, Chantel was in Judge Lerner's division.
And actually, Your Honor, I looked in her other case in Odyssey. It looks like they tried to bring her before Judge Lerner ran yesterday. I'm guessing after this arrest.
Okay.
And she
I'm
refused.
gonna reset her, but if you can get her before Judge Wren, please do.
So, Your Honor's transferring the case?
Yes.
I'll let her judicialist.
I'll find probable cause and send her to Judge Wren.
I'll notify
Okay,
her.
Sabrina Woodrick.
I'll let her judicial assistant know so they can schedule it.
Anybody have Woodrick?
She's North Broward, Judge, I believe.
Up in North Broward, you got Woodrick?
Please don't tell me they took off. Is there anyone there?
Anybody get anybody up in?
According to our
Miss-
house and location, Judge, she might be in the.
Judge, Mr. Reedy's calling up there.
Okay.
Guess just reset her for the afternoon. Judge, it looks like they emptied out north up there.
Well,
I
on
know,
Miss
but-
Woodrick, the court finds probable cause.
She's also on pretrial, Your Honor.
Well,
And pretrial release.
might want to bring her back this afternoon then. If,
I'll bring her back this afternoon. Want me to leave it up here like this? Okay, I'll leave it here.
You can give it to me, Judge.
I can give it to you?
It's trustworthy.
You got it, mean, you sentenced to come back here this afternoon?
I'm gonna give it to the clerk that's coming.
All right. I believe that concludes the docket. Thank you very much, everybody. Good job by everybody.